5 Stone Buildings webinar programme. Before I hand over to the speakers, I'll just remind you of the house rules. So just so you are aware, this webinar is being recorded. If you have any questions throughout this webinar, you are able to use the Q&A box to ask a question, and the speaker will be answering questions at the end. If anybody does not wish to be identified when asking their question, please tick the anonymous box when putting your question in the Q&A box. That way the speaker will not identify you in their response. I will now stop the screen share and hand over to Penny. Penny, we're ready for you.
Well, hello everybody, and welcome to our 5 Stone Buildings webinar. We thought that we would cheer everybody's lockdown up by giving you a Friday lunchtime seminar on tax, which is bound to lift the spirits, whichever tier you're going to be in next week. I want you all to imagine that you're in a mediation, and it's either a 1975 Act claim or it's a probate claim, and you have an offer that's been brought in by the mediator, or more likely nowadays zoomed in by the mediator, and you very much like the look of it. And suddenly, as you're thinking about how you might implement that particular offer, somebody in the room says, but what about the tax? Now, obviously, in an ideal world, everyone will go to the mediation thoroughly prepared for all possible outcomes with full tax advice. But that's not always possible because, of course, sometimes the mediation will throw up a result that no one's thought of. So it is very important always to have the tax implications of any compromise in mind, particularly the case as most Inheritance Act and probate claims get absolutely nowhere near a courtroom nowadays. They will be settled beforehand. And it can be very unhelpful, and I'm sure most of the audience here have been in this situation, where one party says, oh, well, we can't really think about the tax because we're not qualified to deal with that. And it can be quite frustrating sometimes to persuade the other side that you're not really trying to do something devious, but nevertheless, you're just trying to structure things in a way that deals with tax. And the idea behind this webinar really came to me because I've often brought Amanda in on a number of cases by way of a joint instruction of the parties to give expert tax advice on the formulation of a compromise, or to provide an expert opinion on the compromise that the parties have reached as to whether it will work or not. So we're going to just really have a discussion today. I want to bring up some points that come across my desk or come to me in a mediation on a regular basis. And Amanda is going to provide us with the answers. So the first scenario I want to bring up is a situation where there are no proceedings on foot. Somebody has intimated a 1975 Act claim, and we're within 2 years of the date of death. Amanda, is a deed of variation possible in such circumstances? And I'm particularly worried about section 1423 of the Inheritance Tax Act, which of course will have the impact that a deed of variation won't have retrospective effect if there's external consideration.
Well, thank you. Yes, Penny. And can I just support everything that Penny said by way of introduction? Firstly, that everyone goes, oh, the tax. So we're usually the least welcome person in the room. It's ideal, as Penny said, if the tax can be well thought out and all the possible permutations worked out before you do start compromising claims. but that's not the reality. Sometimes it's the case that I see heads of terms that have already been agreed effectively before anyone's thought about the tax. So looking at Penny's scenario here, before an action has even begun under the 75 Act for all purposes, it's perfectly permissible, obviously, within 2 years to effect a deed of variation for inheritance tax purposes under Section 142. As Penny's mentioned, Section 142(3) can disapply the relief that's given, the reading back into the testator's dispositions, if we have extraneous consideration. And it's always, in my view, worth doing what I call an audit in relation to 142(3) when you're compromising actions, and having a little look at anything that could possibly be extraneous consideration. I'll mention another couple of things later that I think should be on your general audit list. One that I often come across that the revenue sometimes get a little bit excited about is where there's any intimation that there might be cross-party payment of costs. So there's a benefit going across because one party is offering to bear the cost. So that's one to bear in mind. But it seems to me that where you've got a 75 Act claim, HMRC are usually in the position where they just don't take the point in relation to compromise proceedings. I think they recognise, because of the whole suite of legislation, the 1975 Act provisions themselves, and Section 142, Section 62, which we'll come on to in a moment for capital gains tax, that really this isn't the arena where they're going to be looking for extraneous consideration. So unless there is something really obvious, like, for example, the costs provision outside of the actual variation, which is mentioned in the correspondence with the revenue, which is unusual in itself to contemplate, then I think you're usually in a position where the compromise is absolutely safe for 142(3) purposes. However, Penny and I have both seen the revenue take the point in probate claims. I mean, the revenue seemed to come from a slightly different perspective. And as I said, I wonder if that's because we have the 1975 Act statutory provisions, and the whole thrust and intention is to enable tax efficient settlements there. Having said that, I haven't seen the revenue take the point for a very long time. Penny, have you seen them take it more recently?
No, and I think that's a really interesting point. But probate claims, and we'll come on perhaps a little later to look at those specifically, one has to be a lot more careful. But that's inheritance tax as far as 75 Act claims are concerned. Of course, there are differences between the provisions for inheritance tax and the provisions for capital gains tax. Amanda, do you want to talk us through those differences?
Well, yes, as I'm sure everyone's aware, the Section 142 provision applies for the whole of inheritance tax, so it applies across the whole of the Act, whereas Section 62 only applies for the purposes of the provisions relating to death. So it is on its terms a more limited provision. The other differences that it's really worth highlighting are firstly, if your deed of variation is going to set up a trust, it's now clear that the deceased is the settlor for inheritance tax purposes, but it's not the same position for capital gains tax purposes, whereby the settlor is in most cases going to be the person giving up the assets. There is, I say in most cases, because there are two sort of distinctions to be drawn here. Firstly, in the position pre-2006 and the position post-2006, where we had some confirmatory legislation which set out HMRC's position in relation to who was the settlor for capital gains tax purposes and indeed income tax purposes. And the other distinction is really to be taken following the case of Marshall and Carr in 1994, and was the reason for the later legislation. Because in Marshall and Carr, in that case, that the House of Lords taking a bit of a departure, if I can put it like that, from both what the Court of Appeal had decided and indeed what was argued in front of them at all. One of those slightly irritating cases where their lordships came up with their own solution. and it wasn't one that had been argued by either party. So neither, I think, the revenue nor the taxpayer were particularly delighted with the solution that Lord Brown Wilkinson found in that case. But it was all based on choses in action while an estate is still in administration. So pre-Marshall and Carr, it certainly seems to me that even post-2000, post-Marshall and Carr, it's still the position that the decision didn't actually cover every single possible factual circumstance. So, for example, post-2000, post-Marshall and Carr, pre-2006, you may have had a circumstance, for example, that the provision that the beneficiary was a settlor wouldn't apply if, for example, administration was already complete. That would be an exception, and was an exception, it seems to me, to the Marshall and Carr principle. Similarly, in cases where you had a different governing law, and particularly where you had a civil law, which has different concepts of administration of estate, then that wouldn't have been covered, and you would have still had the deceased being the settlor. And finally, where you terminate a joint tenancy, because it's slightly different. So in all those kind of niche circumstances, once Marshall and Carr was decided, there were still circumstances where the settlor could be the deceased and not the beneficiary giving up the interest or settling an interest. But as I've said, post 2006, we've now got some provisions in the Income Tax Act 2007 and in the TCGA that make it clear that the beneficiary is a settlor for CGT purposes. And that was the Revenue's view all along. And I think it was because of the anomalies that were thrown up by Marshall and Carr that they decided that they were going to legislate. There's a couple of points that flow on from that I think are important. I mean, firstly, I see quite a lot, and I've seen quite a lot of cases recently where my instructions are centred on whether or not administration is complete and what the tax consequences are, particularly in the international arena where you have issues of foreign domiciled clients or resident foreign domiciled clients. Because in that arena, it can really make a difference when the trustees are offshore as to which sort of tax charges you get, and the executors are non-resident as well. So that's something really to be alive to. You know, when is administration complete? And I've seen a number of cases recently where the executor's year has been extended beyond, I mean, it's almost the executor's decade in some cases. Now, whether or not HMRC end up taking the point that administration is complete in order to get different tax results is a moot point, and I've not seen them do it yet. But it's just been coming across my desk quite frequently, you know, instructing solicitors concerned as to whether or not administration has effectively been completed. So that's one thing to note. The other thing to note here is there's been an OTS report a week ago. It's its first review. They're coming up with a number of reviews on capital gains tax. And one of the really important headlines is they recommend the tax-free uplift on death being abolished for capital gains tax purposes. And with my STEP technical committee hat on, it seems that many practitioners think that that's quite a likely change that's going to be brought into being by the government. I mean, whether or not, I mean, obviously they've got quite a lot on their plate at the moment, what with the pandemic, etc., the economy, whether or not this will be on their list for the next budget, I think is a moot point. But that's going to change the landscape in relation to inheritance tax and capital gains tax planning if we don't have a tax-free uplift on death. So that's worth noting. We've also got a report imminent on wealth tax. It seems to me, again, if I can put it like this, my children will be proud. The word on the street, I think, is it's unlikely to be adopted, but one never knows. So I think probably the warning, the second checklist point, I think that it's worth doing, the second audit, it is just remembering that tax never stands still. It was why I loved tax, why I wanted to be a tax practitioner. I thought, jolly good, it changes all the time. Now I look at the Finance Act, it's 600 pages, and I think, can they just stop changing it, please? So it never stands still. So it's always worth just refreshing your memory on various provisions, and something like the tax-free uplift on death is going to change the landscape if that's legislated.
Thank you, Amanda. So tax never stands still is something that is definitely true. And actually, interestingly, what we're talking about today has actually been there for now quite a long time, subject only to the 2006 changes, which of course remarkably were 14 years ago now. Quite a lot of the cases I see, Inheritance Act cases, involve discretionary trusts. Testators often think that setting up a discretionary trust is actually going to be the answer to the problem of how to make proper provision for their families. And of course it's not, because actually it's often a magnet for a 1975 Act claim, because it seems to be indisputable that being the object of a discretionary trust is not, all things, other things being equal, reasonable financial provision. And quite often, if you can come to some sort of satisfactory arrangement within 2 years, I tend to prefer to rely on Section 144 of the Inheritance Tax Act as a way of making appointments out to beneficiaries. What do you think of that, Amanda?
Yes, I certainly agree, Penny. I mean, I agree with your general point that actually in an ideal world, it's always seemed to me to be preferable for the deceased to think really carefully about what sort of dispositions they actually want to make, particularly bearing in mind the disputes that can arise where you have what has to be a non-binding letter of wishes, which can be interpreted often in very different ways by different parties, sometimes having just a discretionary settlement in order to save first of all, thinking too hard about it now, and sensibly leaving open the door in case there have been any legislative changes for greater flexibility. I think that can often lead to sort of more practical problems in my experience. Having said that, if you do have a 144, as long as you get on and do it within your 2 years, you also at the moment obviously have the benefit of the CGT holdover at the end of the discretionary trust. So it's very tax efficient. The only word of warning, and I always it's quite difficult to give this advice, but don't be too efficient is the advice, because you have to wait until 3 months after the date of death. And there's a really unfortunate case in the Court of Appeal called Frankland, where the really efficient solicitors had got on and got everything sorted out and had made their appointments within 3 months of death. And unfortunately, that wasn't effective for 144 purposes. I mean, the Court of Appeal, you could tell, felt very sort of dispirited that they had to come to that conclusion, but they thought it was plain on the words. So that gives us a little breathing space. What with the 10 years of administration and the 3 months of action, I mean, there has to be a happy medium somewhere there.
Amanda, thank you very much. So I want to change scenarios now. We're not mediating at the start of a dispute. We're mediating when proceedings have been on foot, perhaps been on foot for some time. So let's say it's about 3 years since the date of death. I think Amanda and I have been involved in cases where it's been rather a lot longer than that, but let's assume it's 3 years. So the 2-year window for either a deed of variation or a Section 144 appointment are long gone. Of course, as far as 1975 Act claims are concerned, any order that is made under Section 2 of the Act will be retrospective, and that's actually embodied in the Act itself in Section 19 of the 1975 Act. And for inheritance tax purposes, it's reflected in Section 146 of the Inheritance Tax Act 1984. And very helpfully, that specifically says that there's no problem with a Tomlin order, which of course is always going to be the most or the easiest way in which to settle your 1975 Act claim, if it makes sense. And that's section 1468, which makes it clear that, that those terms embodied in the schedule to a Tomlin will be retrospective if they are terms that could have been made under section 2. Now, that is a really important point, and it's always worth looking at what you're putting in that schedule to the Tomlin to make sure that either they have no tax implications at all, or the terms are terms that the court could order under section 2. And for those purposes, it's really worth looking at the width of section 2 of the 1975 Act, because actually it gives the court an awful lot of powers to make consequential orders, for example. But if, for example, you've got a case where you're settling a 1975 Act claim, and maybe you're also settling a dispute about a partnership as well, which is not uncommon, then be very careful that the provisions you've got in your schedule are going to be retrospective, both for that, but both for that particular aspect of matters. Are those provisions, are those orders that the court could make under section 2? So that's inheritance tax, and that's something I suspect that all of us who settle inheritance tax claims are familiar with and use all the time. But what about capital gains tax, Amanda? Where are we there?
Well, thank you, Penny. It's not quite as straightforward with capital gains tax, particularly if beneficiaries are giving up interests. And I've certainly seen it argued that if, for example, you're outside your 2-year period and you're giving up something, you could be regarded as a beneficiary as disposing of an interest in an unadministered estate. Back to thank you very much, Marshall and Carr, in the House of Lords. And in those circumstances, I have seen HMRC suggest that the base cost is nil. Now, again, it's not something that I've seen HMRC take with any degree of force, or take recently at all. But it seems to me that if you are going to have transactions where a beneficiary is giving up an interest, then it's much safer to ask the court to make an order under section 2, because then you have the necessary cover that Penny's just explained. The other route that I do quite a lot now with HMRC, and particularly in circumstances, for example, where you've got charities involved, or you've got something like transactions in securities, if you're rearranging corporate interests in order to come to a compromise, is it is possible to go to the revenue and make either a non-statutory clearance or to make a statutory clearance. For example, the transactions in securities rules have a mechanism for clearance. And if you're not right down to the wire, i.e. in mediation and calling for advice, but you're thinking about this in advance, I found that's very effective. And the revenue can be very amenable if they understand that this is really, in the best interest of all the beneficiaries, and that nothing that is too aggressive is going on, and we'll come on to that a little later, then you can get advance clearance from the revenue. And that gives everyone, particularly where the sums are very large, a great deal of comfort if you can get that advance clearance. And I've even had HMRC being so amenable in a charities environment that there were other company law issues in relation to what was being done, a disposition that was occurring. But they even sent counsel to court to tell Geoffrey Voss, who was sitting on this case, the Chancellor, that they weren't going to charge any tax on this because they agreed it was a charitable matter. So it's worth just bearing that in mind, particularly in very high value cases where there's a great deal of nervousness, that it may be worth approaching the revenue in advance and saying to them, look, is this all okay?
Yes, Amanda, that's very, very practical and good advice. But obviously this CGT issue does worry people because of the risk that a beneficiary could be regarded as disposing of an interest in an unadministered estate, and that's obviously of considerable concern. But HMRC don't seem to take the point. And in their guidance, they suggest that if it's a case where the court has to approve the matter on behalf of a protected party, for example, a child or somebody who lacks capacity, then there isn't a CGT problem. They will accept that. I've never quite understood that, Amanda. Can you explain why they take that view?
Well, I think that, and there has been and is some confusion. I think it all boils down to what actually is consideration in these sort of circumstances. And there were a number of cases sort of going both ways that suggested that when you're compromising something, or indeed there was one in relation to the giving of holdover relief, whether or not that's consideration for these purposes, because the revenue also grapple with this, for example, in the context of Section 10, which we'll come on to, and whether or not it's effectively a commercial bargain, which is really what's going on here. But I think that they have recognised, although I don't think they've ever set out fully the reasoning for their manual position, they have set out that if the court actually has to give the approval, as I've said, I think it's all part of this sort of underpinning of the fact that there's statutory provisions, both in the 75 Act and in relation to variations before 2 years, which really underpin that there shouldn't be an adverse tax charge. So I don't think, Penny, it's particularly supported by the cases, which go both ways, but I think it's just their approach. And although obviously we don't construe the manuals as law, I mean, it's not statutory, they're not statutory provisions where there is a positive indication in favour of the taxpayer. And as I've said, where it's a straightforward case, it seems to me you would be entitled to rely on that indication in the manual, and why it's better to ask the court to make the order under Section 2, because they're much happier with that sort of factual scenario than a compromise without an order.
Thank you, Amanda. So we're back in the mediation room again. Let's say we have a case where it's a claim by a child. The estate is left to a spouse, we're beyond the 2-year period, so we can't use Section 142, and so we're into the territory of needing a court order that will fall within Section 146. The main aim, bearing in mind the will leaves everything to the spouse at the moment, is to try to avoid having an inheritance tax charge by settling this 75 Act claim in circumstances where we wouldn't otherwise have a problem. So what do you think about the use of a short-term life interest for a spouse? And to put that in context, if you're going to use a short-term life interest under Section 142, Section 142(4) provides that it's got to last for longer than 2 years. That's the statutory provision. But what about if you're doing it in a court order in relation to 146?
Well, as you've said, Penny, I mean, 142 has always seemed to me to be pretty clear, because we've got the statutory provision that it has to last 2 years. But obviously with 146, we don't have any such restriction. I've come across the revenue looking at periods that are shorter than, say, 5 years with a questioning eye. That tends to sort of pique their interest, if I can put it like that. It's always seemed to me, I mean, I always test this with my sort of tax background in a sort of old-fashioned Ramsey perspective. And I don't know if, obviously the Ramsey doctrine was all about preordained series of transactions, often things going round in circles, where steps were inserted that didn't have a commercial purpose. And I always remember the warning in a case called Pigott and Staines, where they were looking at very short timetables for things being done in those days. But 10 months wasn't enough of a gap for Pigott and Staines for people to go off and reflect and think about things. So I always take that sort of under 2-year period as being sort of, although permissible by 146, not the sensible course of action. It has always seemed to me that 2 years, bearing in mind we have a very equivalent position in section 142, it would be difficult for the revenue ultimately to win on the fact that that's too short a period. But if you have got the capacity to, say, give a 5-year period, that seems to me the safest option, because what we're looking at here really is commercial reality, and we'll come back to that. You know, having the tax position follow the underlying position, and where you've got a 5-year life interest, where income will in principle be arising to the spouse, it seems to me that that's really grounded in reality. And couldn't really be criticised by the revenue as being something sort of very, very short-lived and temporary and inserted for a purpose that was in any way questionable for tax purposes. But it's a bit of a fine art, this, isn't it? Depending on what exactly the client needs that's in front of you. But that's always seemed to me to be a sensible sort of way of looking at it. Risk parameters between 2 and 5 years, and 5 years plus being good.
Yes, I mean, I have to say, I think it would be very hard, and I've never noticed HMRC taking the point about any sort of interest that lasts for more than 2 years.
Agreed.
And indeed, I've got away, if I can put it in those terms, with life interests that are much shorter, provided that you can show they're real. Where I have had issues raised by HMRC is in relation to whether it was a real life interest. In other words, did the widow get the income? And this can actually cause quite a lot of problems when you're negotiating, because if the parties have agreed, for example, that the widow's going to get £2 million, let's say, but it's a big estate and the widow's entitlement to income is, for example, £500,000, the parties are going to be very reluctant to agree a 2.5 million deal, when in fact what they actually wanted to pay her was 2. And the way that I've seen that dealt with in the past is to actually work out what the income would be and make sure that any settlement includes the income, so that HMRC can see the income being paid to the widow, which is really important. There has to be reality about it. But on the other hand, the paying party doesn't feel that they're being taken advantage of by suddenly it being said, well, actually, you really need to pay the income to the widow in any sort of intervening period. So that's really, particularly in high income estates, that's really important. The other thing that needs real thought is the potentially exempt transfer that will occur on the termination of the widow's life interest. And I'm going to ask Amanda whether she agrees with this in a moment. There is a difference between a life interest in favour of a widow which you create and which isn't in the will, and a life interest which is in the will. But Amanda, would you agree that if you terminate a life interest which you've created to make the settlement tax efficient, that will be a potentially exempt transfer?
Yes, I do agree. Yes, I do agree with that, Penny. And just this discussion just throws up the other point that it's probably worth us just mentioning again, which is that obviously we've discussed the various provisions in the Inheritance Tax Act, Capital Gains Tax Act, and indeed in the 75 Act that deal with the IHT and CGT provisions. But it's important to remember that there are no equivalent provisions as a matter of general law. It's not read back as being the testator's disposition for any other purposes, and most importantly, as you've said, not for income tax purposes. So the income that arises is still belongs to the beneficiary, even if it's redirected tax efficiently by the provisions that we've discussed. So that's sort of just another practical matter just to recommend, remember. But I do agree, Penny. Yes, I do agree on the pet.
But there is something of a difference between a life interest that's set up in the will. And I see this a lot in practice in 75 Act claims, that you have a testator, perhaps who's been married before with children from the first marriage, who leaves his estate on trust to pay the income to the spouse, perhaps with overriding powers of appointment, and then remainder to his children from his first marriage. And quite often, the second wife is quite disgruntled about only being given a life interest, because most widows or widowers aren't that keen on the idea of being beholden to trustees or only having the income. But if you have an order which terminates that life interest in order to make absolute provision for the spouse on the one hand, which is obviously going to be a non-event for inheritance tax purposes, but then perhaps terminate the interest to make provision for the children, 1466 seems to be clear that that will not be a charge for inheritance tax at all, not even a pet. Are we all right in assuming that's the case?
I think so, Penny, because it makes express provision that Section 51(1) won't apply in those specific circumstances. So I think that is clear from the terms of 1466 itself. It's sort of slightly counterintuitive and surprising that both circumstances aren't treated the same way. But I think that the provision is clear, so I agree.
Thank you. And I think it's a provision that looks almost too good to be true. But it seems to me it was probably introduced to avoid the circumstance where you get to court and the court makes an order, for example, splitting an estate by way of financial provision between a spouse who's got a life interest and children, for example, which would give rise suddenly to an inheritance tax charge and make the whole thing deeply unattractive. And so it's always seemed to me that that's the case. Are there any gift with reservation pitfalls that one might fall into when using this life interest for spouse wees, if I can use that term?
Penny, I think yes, in one circumstance, after the changes in 2006 that we've already referred to, we've now got Section 102ZA of the Finance Act 1986. And in relation to that, if you then follow your terminated interest in possession with, for example, a discretionary trust in which the surviving spouse is a beneficiary, then I think you are going to have your gift with reservation of benefit problem. So you're going to have to look carefully about what you do post termination of the interest. And if trusts are required, then the surviving spouse needs to be excluded from being a beneficiary of those particular trusts.
And obviously there is the case in the Court of Appeal of Goodchild, where there was an attempt to, in making provision for a child, there was an attempt to sort of route it through a short-term life interest for a spouse. I've always taken the view of Goodchild that it's really only if the arrangements are completely artificial that the court is really going to take a dim view. And my experience is that most judges are more than happy to try to make any settlement tax efficient, particularly if they're looking at it from the point of view of approving it on behalf of a protected party. But what's your experience, Amanda? And did we ought to be worried about the general anti-avoidance provision and also DOTAS?
Well, thank you, Penny. I mean, my experience is just like you, that the courts normally bend over backwards to assist a tax efficient settlement for the purposes of the 1975 Act claims. Similarly, where you're varying very substantial trusts and you're going in front to get approval for minors and beneficiaries. I think if there are sort of the usual tax consequences, if I can put it like that, flowing tax savings, such as, for example, preventing somebody getting an absolute entitlement, say at 25, which would bring with it a capital gains tax charge. I think the courts are usually very amenable, go out of their way to assist. But if I may suggest, I think the general anti-avoidance rule and the new DOTAS rules for inheritance tax, which are effective from 2018, are two other things that we all should genuinely have on our checklist of things, our audit checklist of things just to think about when we're giving advice in relation to these sort of issues. I mean, the general anti-avoidance rule only comes into operation where the course of action taken by the parties aims to achieve a favourable tax result that Parliament did not anticipate when it introduced the rules. And critically, that we then have the provision that the course of action cannot reasonably be regarded as reasonable. Now, it's always seemed to me that with those rather tortuous words, we're going to need some cases of the High Court to tell us exactly what can and can't be reasonably regarded as reasonable. I mean, it's a very unusual test, isn't it? A double reasonableness test. So I'm very much looking forward to some litigation in that regard. There hasn't been any cases yet, as far as I know. There has certainly been the GAR panel, which is set up to look at arrangements that may come within the GAR, under which the Revenue have issued a sort of counteraction notice. But they all seem to be within what I would sort of term egregious tax avoidance, remuneration arrangements, which are designed to sort of circumvent employees being taxed in normal circumstances under PAYE. So I'm not surprised that the GAR panel has issued the decisions it has, and we're still awaiting exactly a case that will tell us what those words mean, reasonably be regarded as reasonable. So that throws it back for my purposes really to the question of, I mean, this is a very sort of, fraught question. What is tax avoidance? What is tax mitigation? I hope we all know what tax evasion is. Sometimes the press muddle all of them, but I hope we realise what's actually criminal activity rather than acceptable or unacceptable tax avoidance. And I think we have to come back to the Willoughby case, the evident intention of Parliament. And I think where you have reliefs, where you have provisions such as the inheritance provision for Family Independence Act, where you have usual practice whereby people are settling claims, I think that isn't likely to be termed tax avoidance. And I'd be really surprised that if and when we get a case that explains to us what reasonably regarded as reasonable means, these sort of arrangements fall within it. However, I think it is good practice to sit back and say, do we think this smells right? It's a smell test. DOTAS, I mean, again, this is often forgotten. I find that it's often on a checklist, but it's often forgotten because it was widened considerably in 2018, the DOTAS rules. They came in 2014. And of course, they came in respect of things that, again, we would probably all agree were the other side of the line, and more egregious, complicated arrangements. And there was a very limited provision in relation to inheritance tax. But the wider amendments that are made in 2018 require two conditions to be satisfied. And the first one, you have to have a tax advantage. Now, that's not tax avoidance, that's a tax advantage. Now, that's incredibly wide. It applies to lots of charges, specifically applies to lots of charges in relation to relevant property trusts. It applies to GROBs. It also applies to a reduction in value without a chargeable transfer or a pet. I think that, to my mind, comes back to what we've already been discussing, Penny, about economic reality. If you look at the Supreme Court decision in UBS and Deutsche Bank a couple of years ago, that was an anti-avoidance case. And you really get down to the meat of what is a reasonable course of action for those purposes, and what is effectively real world transactions with real world economic effects. I really like that sentence. I think it was first a Lord Hoffman in Arrowtown, oh no, Lord Nichols in Arrowtown, but has been picked up. And I think that's what we need to look at. Real world transactions with real world economic effects shouldn't be within these sort of provisions. But tax advantage is really wide, but you have to then have arrangements which involve one or more contrived or abnormal steps without which the tax advantage couldn't be obtained. And again, I think the sort of things that we're discussing today should not be within that. The only note of caution that I think I would make is that I was particularly surprised when the Revenue issued their guidance in relation to the DOTAS rules, because I'm sure it was out of a desire to be helpful, but they categorised what they thought definitely didn't fall within, what definitely did fall within, what was in a not sure category. And the categories of definitely not within were things like making a will, a spouse gift, normal expenditure out of income. Now, it seems incredible to me that they were even on the list that needed to be said, because they are certainly the invitation of Parliament in the Willoughby sense to order your affairs in a specific way. So it just gives you a little bit of pause as to what actually, when we get cases on this, and the Revenue are going to consider. But I mean, obviously, deeds of variation are specifically included as not being something that is within the DOTAS provision. So that's very helpful in relation to specific deeds of variation. And by extrapolation, I think it would apply to the sort of things we're talking about here. Just by way of interest, I think there's only one thing in the category of it might do, and that's doing getting business property relief and then having a share buyback. And what they really don't like, and this is not surprising, are reversionary leases and EBTs. They're in the naughty corner. But I think, again, it's always worth thinking, am I on the right side of the line for these provisions? But I'd be very surprised if the sort of things we're talking about would come within either the GAR or DOTAS, unless you were doing something really very unusual.
Thank you, Amanda. I want to turn to the issue that arises from time to time, where you have your spouse life interest and you have a minor child. And you're going to terminate the life interest, but of course you've got to do it either in favour of an outright gift. Most people think that a bare trust for a minor child is not a great idea, certainly those of us who've got children. And have been through the teenage years, I think, would agree with that. And also the other options in respect of favoured trust that you could terminate in favour of. I've only come up with a bereaved minors trust that has absolutely no tax implications at all. And the huge disadvantages, like with the bare trust, the child is going to get the property at 18 unless you advance it on to further trusts. And there is, of course, the so-called, the Natalie named Section 71D trust, the 18 to 25 trust. But then the disadvantage to me has always been that there's a 4.2% charge when capital vests at 25, and you've still only kept the child from their capital at 25. Is there anything else that one can really look at, Amanda, in those circumstances?
I think you're entirely right here, Penny. I mean, I think these are the possible options, and it's always seemed to me that there's very often a real practical difficulty with allowing beneficiaries access to capital at an early age, and I'm involved in very frequently in in applications to vary settlements, and we've been involved, haven't we, together, Penny, in order to prevent this happening. And I think it was one of the real drawbacks of the 2006 changes, that there wasn't enough flexibility offered. And I think you're right, these are your choices. The only thing I'd say, and I agree that 71D obviously only postpones the problem until 25. I get the impression that the courts, even when you vary, are more tempted now to come to the conclusion that by, say, 25, people are in a position, I'm thinking of Wright and Gator, for example, in a position to be able to deal with their affairs. And I agree that the 4.2% charge is, bearing in mind it's going to be paid to the revenue, is unfortunate. But it may well be that it's an acceptable level of charge in order just to get you to that period of time. And I think anything else, of course, we can do it. And my cons often start with me saying to the client that I'm very keen for clients not to let the tax tail wag the dog. We may find that we have tax charges in order to get to the practical position. It may be more important to accept that there are tax charges in order to prevent people having early access to capital. But it's a real shame that the 2006 provisions were brought in the way they were, sort of overnight, without the ability to sort of have some more creative options here in these sort of circumstances.
Yes, thank you. And I couldn't agree more. I think that was one of the misunderstandings of the government that brought in the 2006 changes, that trusts are always bad. And of course, where you've got children, particularly if they're going to turn into vulnerable adults, it's a real problem. Now, I think I mentioned earlier that as far as probate claims are concerned, HMRC do seem to suggest that a deed of variation that settled a probate claim might well fall foul of the extraneous consideration problem in section 1423. But what's often occurred to me when I've been settling a probate claim is do you think that the settlement might fall within section 10 of the Inheritance Tax Act, commercial transactions or arm's length transactions?
I do, Penny, and even more power to our elbow now, if I can put it like that. Obviously, our colleague in Chambers, David Reed, has recently had a case decided by the Supreme Court, the Staveley case. Well, that's how I refer to it, the Staveley case. Obviously, that was in relation to a pension and the omission to exercise a right. But there's a lot of very, very helpful commentary by Lady Black in that case in relation to the availability of Section 10 in relation to inheritance tax issues and commercial consideration. And right at the end, the omission point, which I think isn't in point in the circumstances we're discussing, obviously didn't fall quite the right side of the line, but everything else did. And so I think, yes, and I've often had the revenue agree things on Section 10 and very occasionally Section 11 as well. I think it's another very good tool to have in the armoury because very often, there isn't necessarily just natural love and affection in these types of circumstances.
No, I was going to say that most of the probate disputes I deal with, they're not just arm's length, they're on opposite sides of the playing field. Finally, I just want to deal with this issue. What about if you have competing wills in a probate claim? One of the wills leaves everything to charity and the other will leaves everything to a non-exempt beneficiary, such as a cohabitee. My instinct would always be to agree that the exempt will should be admitted to probate. And then bearing in mind it leaves everything to charity, getting the charity to pay off the competing beneficiary, taking advantage of Section 29A of the Inheritance Tax Act, which somewhat counterintuitively provides that provided the charity uses money it gets from the estate to pay off the beneficiary, that will be effectively won't be retrospective. So you won't read it back as if the will had contained that legacy. But I know that there's been a concern expressed that any good that that particular section does is undone by section 23(5) of the same Act. Do you think section 23(5) is a problem? And perhaps you could tell our audience what that does effectively.
Yeah, 23(5) itself obviously means that you can only apply any funds for charitable purposes. And if you don't apply the funds for charitable purposes, then you lose your charitable exemptions effectively. I've always thought, Penny, that section 29A must take precedence. I mean, for a couple of reasons. I mean, obviously, section 23(5) is part of a much more general provision in relation to charitable release, whereas 29A was specifically enacted in order to cover the sort of circumstances we're dealing with and make sure that you didn't lose your original charitable status in relation to the gift. And secondly, just practically, section 29A was added later. And therefore, it seems to me that when we're looking, as we have been, at the intention of Parliament, it seems to me clear that it's section 29A that takes precedence. I'd suggest, I mean, I haven't had a case in relation to this that has actually needed to go any further, although I've thought about the problem. I suggest that this is one of the sort of scenarios where it would be extremely useful if at some point somebody made a non-statutory clearance to ask the revenue just to confirm the position in relation to this. And as I've said, in the context of charities, I think the revenue are very good. But it would be quite good, and I think if anyone who's in the audience has got a case like that, it may well be worth somebody adding to the general bank of knowledge by asking the revenue by way of clearance that this is the case. But it seems to me the proper view.
Amanda, thank you. We've got one question, well, two questions in fact. I'm probably going to give them both to you actually, but the first is that our questioner thought that the effect of the Frankland case was reversed by the Inheritance and Trustees Powers Act 2014.
Well, I think that this brings into consideration two things that I've said already. Firstly, general checklist, and secondly, tax always changes. You may well be right. Thank you, anonymous attendee. I shall go and check that out. It's obviously escaped my mind today, but it may well be correct. So we'll go and check that out.
I think the point actually is that the trustees are enabled to exercise their powers right from the word go, and that's the change in the general law. But for inheritance tax purposes, you still mustn't exercise those powers within the first 3 months, because that causes a problem for discretionary trusts. So I think that might well be the answer.
Maybe we've still got the same inheritance tax consequences, which was why that was sort of fixed in my mind. But actually, that there's the practical trust provision has been sort of remedied, as it were. So yes, that's very good. That's very good to know.
And the next question, which I think I'll take perhaps with Amanda chipping in, is with reference to section 146 and in particular 146(8) of the Inheritance Tax Act. In a case where you may not want retrospective effect, is it possible to avoid a reading back for IHT purposes by means of a settlement which avoids a Tomlin order, i.e. by accepting a Part 36 offer, which automatically stays the proceedings? And the answer to that is yes. And one thing we haven't really touched upon today is the fact that if you've got a situation where you don't want to lose an exemption and you don't want the retrospective effect, then it may be much easier to settle matters before you've got proceedings on foot. And avoid having an order altogether. And sometimes you want to make sure that 146(8) and indeed 146 generally and section 19 of the Act don't apply.
Absolutely, Penny. In fact, I think that was something else that we'd sort of chatted about, hadn't we, when we were talking about giving this webinar. So I think that that's certainly the case. So I think the lesson is it's worth thinking very carefully about the impact of issuing proceedings before proceedings are issued, and sometimes trying to sort of sit down across a table or across a Zoom at the moment to try and think about the best solution overall. It is sensible in advance of issuing proceedings, and we've certainly had things between us, haven't we, Penny, where we've taken that route. Yes. So that's very helpful.
Well, thank you all very much for listening in. If you have any questions, please, we don't mind answering them as long as they're not going to take hours and hours, of course. But any questions that you have for us, please do email. We'd be very happy to deal with them. And just thank you very much for being such an attentive audience.
Thank you very much.